We're
We're
back.
so we're back with Let's Boil It Down. And today, both me and Bob Kipnis are going to tell you a little bit about assets in a divorce. It's a multifaceted topic. It can be very complex or it can be very simple depending on what the assets are and what needs to be divided. But there are many, many, many issues in this. Number one, the identification of those assets. Number two, the categorization of those assets. Number three, whether or not there's any reimbursement or dissipation due to either the marital estate or the non-marital estate, along with valuation of those assets. So we'll start with identifying assets. Bob, what do you have to say about that topic?
Good morning. I'm glad to be back. So the first area of inquiry would be whether or not there's a prenuptial or premarital agreement. That's what I would look to first to see if we can identify what the marital estate is versus the non-marital estate, because essentially you need to get to the judge what the marital estate is or to opposing counsel so you can start trying to negotiate a settlement.
So there's all kinds of assets though, aren't there, that are, that need to be identified. What do those include?
Absolutely. So first you want to identify any real property, houses, land owned by the parties, any land deals the parties are in, anything to do with real property. Next would be the liquid assets, cash accounts, CDs, money market accounts, stock accounts, while not cash, could be readily converted into cash, things of that nature.
Businesses?
Businesses, absolutely.
And
Very important issue and potentially assets of the marriage.
okay. And what about more recent kinds of assets that we've had to deal with? Cryptocurrency?
Cryptocurrency we're dealing with now, and they're like some of the other assets. The key is how do you value the asset? Start with the purchase price and then go to the marketplace and see what they're trading at.
So would it be fair to say that the very first thing we're going to do is identify the assets and start to create a balance sheet for the parties?
Exactly.
Okay. And the balance sheet would include all real estate, all cash assets, businesses, cryptocurrency, any other type of investment that they may have. Is that correct?
Exactly. And then you have to make a determination whether or not it's part of the marital estate or non-marital estate.
What does that mean?
Well, and there's a presumption under Illinois law that any assets acquired during the marriage are marital. That presumption can be rebutted by numerous things. One would be a premarital agreement. If you say, I came into this marriage with 10 McDonald's restaurants that are going to forever stay non-marital, then you know in your inquiry that goes on the non-marital side of your balance sheet. And that becomes important when you're dividing the marital estate, because one of the factors the court looks at is each party's non-marital estate. I had a case once where my guy had in excess of $5 million. The marital estate was worth 500. So we gave the wife the whole marital estate.
So there can be an inequitable distribution between the parties. Is that right?
That's true. And in Illinois, equitable does not mean equal.
And that's something that we deal with all the time, don't
All
we?
the time.
Everybody comes in and thinks that equal is what's going to happen, and that's not really what it is it?
No, it's not. And that's something we talked about the other day when you have to manage your client's expectations. Because again, equitable does not necessarily mean equal.
So in your case, the wife got 100% of the marital estate because it was such a small amount compared to the husband's non-marital
That's
estate, is that right?
correct.
And there's other factors too, aren't there, in why somebody might get more than 50%?
Sure. There's various factors that the court looks at when dividing the estate, including but not limited to age of the parties, health of the parties, lifestyle established during the marriage, those types of issues. And if you have an economically disadvantaged spouse because of a prenup or some pre-existing assets, then that has to be taken into consideration when you're dividing the marital estate.
One of the factors is also the opportunity to acquire assets in the future. So would that include, like, if one of the parties was going to have a greater earning capacity in the future?
Absolutely, and that also ties into spousal support.
Okay. So when we're dealing with, identifying assets and putting them into the non-marital or marital category, it's gonna be very important, can't it?
Oh, absolutely, that's key to the case.
And it's also then after we finally identify them and we kind of establish a balance sheet, did we then move to the valuation of these assets?
Yes, that would be the next step to try and round out the balance sheet, and instead of just classifying them, quantifying them, and the number you ascribe to each asset so you can then move over to dividing the estate.
We talked about non-marital just briefly a second ago. What is the definition of non-marital in Illinois, if you know?
Well, it's an estate that's not contemplated for division. It's contemplated and factored in when dividing the marital estate, but you don't divide a non-marital estate. You just award it to one party or the other. The next natural inquiry would then be, is the marital estate due any reimbursement from the non-marital? So I've run into that as well, where the marital estate pays joint income tax on a business that's non-marital. What do you do with that?
Yeah, well, that's reimbursement, and there's a lot of case law on that. But let's go back to the definition of non-marital for a second, so that we can make sure that everybody who's listening gets the idea. So, isn't non-marital something that one by the parties acquired before the marriage, by
Could be.
by inheritance, or
Yeah,
by gift? Is that correct?
absolutely.
And that's really what non-marital property is, isn't it?
Yes.
Okay. And the only exception or the additional way that you could have non-marital property is if by chance your prenuptial agreement gave somebody an interest as their non-marital, even though it might have been marital. Is that correct?
Exactly.
And you can do that in a prenup, which we discussed, the other day,
Or a postnup. You can do it after they're married as well.
or a postnup. But typically, it's if it's inherited, gifted, or acquired before the marriage, correct?
True.
Okay. So now we have the definitions of marital and non-marital. We've started our balance sheet. We've got the listing of all the assets on the balance sheet. We move to the valuation, and we'll get to reimbursement and dissipation in a second, but let's stay with the valuation here for a
So it
second.
depends on the asset. If it's a stock account, you get a strike price and you get a date and you multiply it by how many stocks you have and determine what the amount is. Very different from a business valuation, which is another topic for another day. We could do a whole session on it.
Probably 6.
Right.
How to value a business.
And then you would need to value the business, whether or not it's marital or non-marital. You could look for a stipulation from the other side as to value, or you could just hire a forensic accountant and evaluator to
To
assess
value the
the
business.
price. Yeah.
So the business is one thing, and business valuations can be very complicated. Is that correct?
Oh, yeah.
And the valuators can disagree,
And they do from time to the time.
and by a lot.
Yeah.
I mean, I had a case where my client, my valuator evaluated for my client at about $6 million, and the husband's valuation expert came in at $100,000. Now, the husband's valuation expert was notoriously
Low.
hired. Well, he was hired as a hired gun.
Oh, yeah.
So he would do what the other side wanted. But, so I mean, you can have those kinds of variations, and that if you in cases, can't you?
Of course. And then ultimately it's up to the trier of fact. Or
The
the
trier
judge.
affects the judge, right?
Right. There's no juries in Illinois divorce court.
I just had somebody the other day who was shocked at that. They thought they were going to have, as this woman put it, 12 people raising their hands, okay, and voting. And it was like, no, nobody in the audience is going to be raising their hands and voting. The man or woman on the bench is the person.
Right. I still get that question all the time. So there are no stupid questions for your prospective or current divorce lawyer.
And that's exactly true. The one thing, and I know we talked more about hiring a lawyer the other day, but just to fill in that little blank, no dumb questions. Please ask whoever you hire whatever you need to know, because as I said the other day, education and empowerment are really two very, very, very important aspects of going through this process. But back to the valuation. So that's how we value a business, and we'll talk more about that on a different time. But what about real estate?
Well, real estate, we just did it in a case where we agreed to the same real property appraiser, just so there weren't two competing ones. And he did the walkthrough and came up with a valuation that everyone could live with.
And that's a typical way of doing it. But aren't there differences between valuing residential property and valuing investment property?
Oh, absolutely. If it's income producing, it's a whole nother ballgame than a residence.
And again, you need an expert to come in and do that, right?
Yeah, for sure.
And there's a lot of people who say, why can't I just have my realtor come in? Why can't the realtor in the neighborhood just give me a value, and why can't I live with
There's a stream of income that has to be reduced to present value, just to touch upon that. So no, just the garden variety real property appraiser cannot do that.
Yeah. And even on residential real estate, we really can't use a realtor because they're not considered an expert. Is that correct?
Right.
So that we need to hire the qualified real estate appraiser versus a realtor to come in and
Absolutely.
give us a value.
Absolutely.
But don't we always try to go to realtors just to get the ballpark?
Yeah, so it's a shortcut, but you can ask for a market analysis as opposed to an appraisal, and the market analysis will put you into a ballpark. You could reach out to the other side to see if you want to go the full route of an appraisal or if you can stipulate to the value.
And a lot of times that's what we do, right? We get two different, the
Right. It's
husband.
not an exact science anyway, because it's essentially based on comparables. So they try and find exact properties, which you never can, because there's something unique about every property, either location or layout or
Condition.
condition's a big one. Yeah, so it differs.
Right. So we can get the market analysis as a stopgap measure, but then ultimately on real estate, we need that appraiser to come in if we're going to need to go to trial or before take it to a trial of fact, correct?
Yes.
And I found that appraisals will tend to be lower than like market analysis or that, because what I've learned is that most appraisers do most of their work for banks, and therefore what they're really appraising is whether or not it's good for a loan. And so they're just looking to get it in at a value that's in excess of what the mortgage lender is going to lend.
Right. I've had that same experience.
Yeah. So sometimes getting the local realtor to give you what they really think they can get for it can be far more helpful than an appraisal in terms of negotiating, not usable at trial, but in terms of negotiating, finding out what it would really sell for is really the key of what we're trying to do, isn't it?
Yes, and it's quicker and cheaper and easier to
Yeah.
do the market analysis.
And generally, they have a lot better idea of what's going on in the neighborhood too.
Right.
And that's which an appraiser is doing them all over the county, the state, the Midwest.
Then you have to take a step back and determine when was the property purchased, what was the source of funds used to purchase the property. Does one party or the other want to keep it? That's a big question to answer for your divorce lawyer. And if so, how do you offset that equity in the balance sheet?
And so now we've got like the business valued, we've got the real estate valued, we've got all of this on the balance sheet, and we've got the liquid assets, which are relatively easy. But when we're looking at stock portfolios or crypto or any of these types of appreciable assets, do we need to look at the tax consequences?
Absolutely.
And what would that involve?
That would involve the purchase price at the time of purchase to see what the capital gains would be to liquidate the asset. So if you think there's $1 million stock account and you think you're getting 500, you're not. And that's something that you need to impress upon your client.
Yeah, and that's something, again, that clients need to be educated on, is depending on what the basis, the tax basis of each of these assets is worth, that can affect what the real net,
Absolutely.
okay, and the net is what you're really interested in when you're resolving a case, is it
Mhm.
not?
For sure.
The one asset that we forgot to mention earlier was retirement accounts.
Right. We haven't gotten there yet.
Okay. All right.
How much of the retirement account was earned during the marriage? How much of the stock account is vested and as vested during the marriage would be some initial inquiries to
Right.
determine.
And then there's a couple kinds of, retirement accounts. There's defined benefit, and then
401ks, IRAs, Roth IRAs where the tax has already been paid.
those are more defined contribution plans, correct? So, like a 401k, an IRA, those are defined contribution plans, which kinda means that you're contributing, your employer might be doing some match,
Match, right.
but it's not a defined benefit. What you get at the end is more based on how much you accumulate, correct?
Right.
Where a defined benefit is the old pensions. If you work this many years, if we will agree to pay you a percentage of your final salary or an
For
average,
life.
for
Right.
life, right?
Right.
So
And
that's
hopefully that entity doesn't file bankruptcy and wipe you out.
Yeah, then that used to happen, which is one of the reasons that a lot of our ERISA laws came into effect. Is that true? And the ERISA is the pension laws that the federal pension laws that govern what employers can do with this money, whether they can bankrupt it. They kind of started to protect it a little bit with these ERISA laws, did they not?
Yeah.
Okay. So it makes it a little safer these days, but still. And again, I mean, this retirement accounts are not taxed at the time that you contribute. So they're taxed when you take it out. So that can be a different result for each of the spouses.
That's a key inquiry in and of itself as well, because the retirement accounts is not worth what you think it's worth.
Yeah, you've got to tax affect it.
And it's good to associate with an accountant who can give you some projections in that regard so you know what you're dividing.
Right. And if somebody is going to have a higher income bracket at retirement than the other one, that can make a difference also, we're correct?
Absolutely, because now in your divorced life, you can no longer file joint income tax returns.
Right.
So any tax on the withdrawal of those funds will be yours and yours alone.
And people ask this question all the time. What about Social Security? And that's not an asset, is it?
No, and that's not something we can control either. That's federal law, and that's it's called comity, COMITY. Federal law controls.
And what federal law says is each of you gets your own Social Security,
Predicated on what you've paid in, the duration of your marriage, etc.
and we're not allowed to divide the Social Security benefits between the parties, correct?
Correct.
And but one thing that I think people miss is that right now, under those laws, the under earning spouse or the lower earning spouse, they will have the right to take their Social Security benefit or to take a benefit based on their spouse if they were married for more than 10 years.
More than
correct?
10 years, correct.
And that's something that we need to factor in, and we'll talk more about that when we get to support. But it's a question that's asked of me all the time because people just think when they're talking about retirement accounts that Social Security would factor in there, and it just doesn't. So
Right.
we need to make that clear. And what about these defined benefit plans? So if you're going to get a pension, okay, at the end of your retirement, can the other spouse get a part of that?
Yes, and so in the past, we've used actuarials to help us value some of those pension rights or benefits.
So-
And then you true up or true down to make it whatever percentage division you're trying to gain.
So you're doing that if you want to offset the pension benefit against other assets, right?
Right.
But there's also a way to divide the actual benefit between the parties, correct?
Right.
And is there something called the Hunt formula that does that for us?
There is.
And what's the Hunt formula, Bob?
It's a legal method for evaluating, dividing pensions in a divorce case by calculating the marital share.
And how do you do that?
It's the number of months for service over the number of months of marriage times the benefit brings us to our number that we are looking for.
So to put it a different way, the numerator is the number of months of marriage. The denominator is the number of months that the spouse was employed by that entity.
Correct.
And then we multiply that by the benefit.
Right.
And then we divide that by whatever percentage we're going to divide the estate under. Is that
Right.
correct?
Exactly.
So we come up with a number that gives a fair distribution of that pension benefit to the non-participant spouse. Is that correct?
True.
And when we do that, we can also do this if there's like 401ks or IRAs where there was some money in there before the marriage and then more was contributed after the marriage.
Exactly. And we have to keep in mind that transfer is a non-taxable event. It's only taxable to the spouse when he or she withdraws the funds.
Right. So we don't have a taxable event when the non-participant spouse receives their money from the 401k or the IRA, correct?
Correct.
They get it into a retirement account in their own name.
Mm-hmm.
And then when they withdraw it, they pay the taxes on the part that they received. Is that correct?
Right.
Now, there's also a provision that allows people to take out money from qualified retirement plans at the time of the divorce without a penalty. Is that correct?
Correct.
So let's say, and I've done this so many times, let's just say that the husband has a large retirement account and that the wife is going to get an interest in that retirement account. And she needs cash for, to move forward, maybe to pay off some credit cards, maybe to buy a new car, maybe to buy a new house, whatever the case may be. She can take a one-time distribution at the time she receives the husband's qualified, like 401k,
Right.
and not pay a penalty if she's under the 59 and a half. Correct?
Right. I was going to say she needs to be 59 and a half.
No, under 59 and a half, she can take the one-time distribution.
Right.
Right. And if you're over 59 and a half, there's never a penalty.
Right.
Right. So, but she will have to pay the taxes, correct?
Mm-hmm. Yes.
So it's a way of transferring cash to a spouse that may not be getting a lot of cash in a divorce.
Right.
And have you done this?
Years ago.
Okay. I've done it fairly often, and I just recently did one where the client didn't have the ability to pay the attorney's fees at the end of the case. So what we did is that we made sure that she received enough of a distribution from the retirement account to cover attorney's fees. I had another one recently where it went the other way. What the judge did, which I thought was very unique, was that she ordered the husband to pay the attorney's fees of the wife, and he didn't have enough cash. So she ordered more retirement money transferred to the wife, and then allowed the wife to take it out of the retirement account without the penalty. And it was really from the husband's share of the retirement account.
That is unique.
So it worked out where everybody was happy. The wife got her attorney's fees paid by her spouse, and at the same time, the husband didn't have to go and beg, borrow, steal, or take out a loan,
Mm-hmm.
to pay those fees. So there's a lot of different things that can be done with retirement accounts.
Sounds like a good remedy or way to get to it.
Right, and there's a lot of things that can be done with retirement accounts at the end of a case, right?
Yes.
And sometimes what we do is we offset, like the house. If one party wants to keep the house, and the other party has retirement money, we give them more of their retirement money to offset the value of the house to get to a equitable division, correct?
I did that recently where we did not divide many of the retirement accounts because it necessitated quadros, letters of direction, a lot more work, whereas we just gave her 2 of the whole assets.
Yeah. And so there's a lot of different ways that you can divide assets when you get there, correct?
Yes.
Okay, so let's go back to our balance sheet. So we listed the assets. We determined whether they were marital or not marital. And then we've now put values on them. Is that correct?
Right.
So, and we talked a little bit about then how you divide it, how it does not have to be equal. But the next part of that would be coming to a consensus on how those assets get divided, right?
Right. You got to get to a meeting of the minds, as they say, to see how to divide the estate. If you can't determine how to do it amongst yourselves, a lot of times a pretrial with the judge to get some recommendations on how to divide assets is warranted.
And a pretrial is when the parties or the lawyers go back and talk to the judge and give the judge kind of a nutshell synopsis of the case. And then the judge makes recommendations as to what the judge believes he or she would do if the case was before them on trial, right?
Exactly. And usually you got to go into the pretrial with a pretrial memo that you've previously tendered to the court so they know what the case is about
And
and what your
client help
issues are.
draft that pretrial memo?
Well, the client reviews it for accuracy, and some clients do help draft while others just review and approve.
And some clients become problematic and want to write their own thesis to the judge.
Right. You don't want to over lawyer your case in that fashion by adding another non-attorney to it.
Right. And we've all had this situation where clients want to be involved, okay, in all of this. And where I think clients need to be involved on a certain level. Have you seen cases where the client has been overly involved in the preparation of the balance sheet or the pretrial memo or many of these initial
Absolutely.
tasks?
Absolutely. And you got to strike a balance as to what is readily usable and easily definable. And sometimes if you meddle too much in it, the lawyer does know best at the end of the day.
Yeah, and I think we all know that, there's the judges, and I think we said this the other day, the judges are there to give you a decision. They're not there to do what people want as justice. So that you're not going to write a pretrial memo that is sitting there telling the judge all the bad things that the other side did or all the terrible things that went on during the marriage, because most of this is just not relevant to what the
Right.
court wants or needs to hear, right?
At the end of the day, Illinois is a no-fault state. So while you may want to get your pound of flesh, you don't get much traction from it.
Yeah. I mean, now there's exceptions to that, which is like, if there's domestic violence, I mean, that might be important to point out to the court.
Sure.
And then we get into dissipation, which is one of the bad acts that the courts are interested in and that our statute actually says they must consider. Is that correct?
Absolutely. It's the expenditure of marital funds during the marriage for purposes unrelated to the marriage.
And when you say during the marriage, that includes the separation, correct?
Yes, and a lot of times there's a lot of dissipation you can find there because one spouse or the other leaves town, takes up with a girlfriend or boyfriend, and starts on a spending spree.
Right. So any sums of money spent on a third party, like a boyfriend, a girlfriend, is any other significant other or dissipation, correct?
Right. I had one recently where the husband claimed that he owed his mother over $100,000, and after we filed, he gave her $100,000. So we had to go in and get the money back.
Right. And we've both had cases where somebody has a significant other and they're taking them on vacations, they're buying them gifts, oftentimes very expensive gifts. And all of that is dissipation, correct?
That's all dissipation. Gambling is historically dissipation. Drug use, alcohol use, those types of things
Yeah.
can be dissipation.
So okay, so now we say that one of the parties dissipated $100,000. Okay, what does that mean?
If we're dividing the estate 50-50, he'll owe her $50,000 from that dissipated 100. So it's another line item on the balance sheet.
So it's as if he already got $100,000 of assets.
Exactly.
And they're just not there anymore.
Right.
So that goes on the balance sheet, and the wife is entitled to her 50% of that.
Right. We have to make the wife whole in that regard.
And the theory is the other 50,000 was his money to spend as he chose.
Right.
And that, but it's gone. So he's now $100,000 down on what.
And a lot of times we give advice at the outset. It just makes the case murkier, if you would. It makes it more difficult to get through because emotions come about when, one of the spouses is whining and dining a new significant other. Same with don't post on Facebook or Instagram. Just shut down your social media when you're going through a divorce. It doesn't help to get a case settled.
It really doesn't. And, what you forget is that people can get to it. So, I mean, I have my staff looking at the other party's social media all the time to see the partying, to see the new significant other, to see anything else that they may be posting that may lead to dissipation or to other.
Right. You could find good evidence on a Facebook page and from posts that one of the parties is doing.
Instagram, any of them, it's all there, and you can find it and you can use it, correct?
Right. It's a good research tool.
It's a good research tool, and it can be evidence, right?
Oh, absolutely.
We get it all the time where, no, I wasn't with that person, or no, I wasn't there. And now you've got a Facebook or Instagram or some post.
On the beach having a cocktail.
Right. Yeah.
Exactly.
With the significant other.
With
that
the
you deny him.
other.
Yep. And we've all seen that. The judges have all seen it. And we all know that it goes on. And so posting is just not your best interest. I don't want to talk too much about parenting because we're talking about assets, but another reason not to post is stop posting your little children on your Facebook and Instagram. It's just not appropriate. People can see it. It can be used against you in a custody, parenting case. Just not a good look. To post a family photo once in a while, there's nothing wrong with that.
Right.
I had a case where the wife was a Instagram
Influencer, yeah.
let's say, and she was posting every day. She was staging her kids. And it was like, "Well, why are you doing this? And why do all these strangers have access, know who your kids are, what they look like, where they hang out, all these things that maybe aren't appropriate in."
And then the comments become inappropriate.
Right. Right. So, just our advice is to just don't post on social media when you're going through this. You can resume when it's final.
Right.
Just make sure that any posts are bland
Mm-hmm.
and that. So, okay. So we talked about dissipation and we touched on reimbursement earlier, but let's go back to that. So the statute provides that if one estate, meaning marital or non-marital, contributes money to the other estate, either marital or non-marital,
Right.
that they may be entitled to reimbursement. Is that correct?
Right. You got to prove by clear and convincing evidence the sums that have been tendered to the other estate in order to get it back. But yeah, that could be a big ticket item.
It can't. So you've got like a situation where maybe the husband took money from his non-marital funds and, put them into a joint investment. Is that correct?
Right.
And
That's a good example because then it's transmuted into marital property.
right. So now it's transmuted into marital property, and the issue becomes, was it a gift from the husband to the marital estate, or should he be reimbursed? Should his non-marital estate be reimbursed for that investment?
Right. A lot of times we get the answer it was for estate planning purposes, which usually doesn't fly if it's just a gift to the marriage.
But a gift to the marriage, gifts have to have a donative intent, an intent to never receive it back,
Right.
and a few other factors. Is that correct?
Correct.
So if you can show that that wasn't your intent, you could possibly get reimbursement, correct?
Right. It's called an under 503C2 is what we refer to that as.
Okay. And under 503C2, there is a part that says that if the transfer was for estate planning or other financial planning purposes. Is that correct?
Yes.
So something along those lines would be, I took my non-marital and I put it into a trust, and I named my wife as, the
Irrevocable beneficiary, for instance.
yeah,
Yeah.
something like that. And that was clearly just done for estate planning purposes, so you could, in fact, get that back. Is that correct?
You could try.
Yeah, well, an irrevocable trust is gonna be hard.
Yeah.
You know, but if you did it for it, I see it all the time where people go to accountants, they go to financial advisors, and these accountants, these financial advisors believe that these people are gonna remain together forever. So they
Right.
start making recommendations of, well, let's transfer this asset that belongs to you over to her or from her to you, for these tax purposes. And now the parties get divorced. Um, You've got to trace that and then make the claim or reimbursement that it was only
Right.
done for these accounting purposes,
Right.
tax purposes, right? Hard to prove?
Hard to prove.
Okay.
Keep your non-marital.
Right. It's the simplest answer, but unfortunately, not everybody watches our podcasts.
Not yet.
We're going to keep having people walk into our office with these situations. And I mean, it should be out there. It isn't out there. People don't know this. They believe their accountant or financial advisor or estate planning lawyer knows what they're doing.
Mm-hmm.
But these people are not prepared to prepare you for a divorce, correct?
Correct.
So, Bob, you made a comment earlier about how one party or the other might want to keep the house, okay, or a particular asset.
Correct.
Remember that? And it reminds me of the Zsa Zsa Gabor quote of, "I'm a great housekeeper. I always keep the house every time I get to."